Thank you, Mr. Shima. If counsel in 124-861 State versus Jacobson would like to come forward. While they're coming up and getting settled, I'll explain a little bit about, you will, before we have come to the courtroom today, the court has received briefs and arguments from the parties. We have, both of the cases that we will be hearing today have made their way through a district court, a trial court, with an appeal then to the Court of Appeals, which if you haven't toured the building yet, you may be, and you will find that they are housed on the second floor of this building. They are in an intermediate appellate court. From there, the parties, in this situation, the state had reasons that it didn't want to accept the decision of the Court of Appeals. So they have the right to petition this court for us to grant, in our discretion, review of that case. We see somewhere between 700 and 1,200 petitions for review a year. We obviously can't take all of those. So we have criteria we usually use. Often it is that it's a legal issue that is likely to be repeated. So we are providing guidance to all courts about that issue. It could be, the Court of Appeals sets in panels of 3. Occasionally, those panels will disagree with each other on a point of law. And so we will take the case to resolve the disagreement. And there are other reasons as well. But we do have all of the paperwork and the briefing that has come before us in addition to our own research. So as we do go through this process, you may see us looking at either computers or papers that we may have in front of us as we refresh ourselves about some of the arguments that were made, some of the legal authorities that are being cited. Please know that as we do that, we are doing it not because we're distracted from the argument, but because we are trying to focus on the fine detail of the argument and better help us understand what the attorneys are arguing. With that, Mr. Obermeyer, if you would like to come to the lectern, we'll begin.
Madam Chief Justice, and may it please the court, Petitioner Appellee, State of Kansas, appears by Assistant District Attorney Daniel Obermeyer. Madam Chief Justice, I would ask the court reserve 5 minutes for rebuttal, please.
5 minutes is reserved.
Thank you, Your Honor. The issue which this court is dealing with today is to what extent Wettrick is still effective. I'll begin by laying out some of the legal history for the benefit of those present here. So I'll just try to oversimplify that maybe a little bit, but hopefully get to the essence of what this court has previously held and why that's important. And then I'll address its application to the case at hand. As the court knows, Kansas has a sentencing grid which determines a presumptive sentence which every criminal defendant faces as potential punishment. And to determine that potential punishment, we look at the severity level of the offense and the criminal history, which is dictated by person and non-person felonies. To determine whether something is a person or non-person felony for a Kansas offense is a simple matter. The legislature has designated whether or not it will be a person or non-person felony. For out-of-state offenses, there is a lengthy history as to whether or not an out-of-state offense will be counted as a person or non-person felony for purposes of the Kansas sentencing guidelines. Importantly, this court has held in State v. Vandervoort, the law which was in effect at the time the defendant was sentenced back in 2015, that in order to determine whether or not an out-of-state offense should be counted as a person felony, the sentencing court is to look at the closest approximation of that out-of-state offense to a Kansas offense. If there is no closest approximation, then that shall be scored as a non-person felony, which lowers the potential range of punishment a criminal defendant faces. That was the law of the land up until State v. Wettrick, which was decided on March 9th, 2018. State v. Wettrick held that the closest approximation test was no longer the law in the state of Kansas. Instead, in order to determine whether or not an out-of-state offense should be a person felony, the out-of-state offense had to have elements which were identical to or narrower than a comparable Kansas offense. If the elements were broader than the Kansas offense, then it was to be counted as a non-person felony. The effect of this in many criminal cases was that criminal histories for many criminal defendants were reduced significantly, as what were previous person felonies under the Vandervoort test now became non-person felonies under Wettrick. That, by way of background, is the law up until June 27th, 2019, when the legislature overruled Wettrick, and subsequent decisions by this court have clarified that while a defendant is entitled to a change in the law during the pendency of an appeal, that otherwise the law in effect at the time a defendant is sentenced is the controlling law, and a legal sentence cannot later be rendered illegal by a subsequent change in the law. The court has also subsequently held that Wettrick is such a change in the law.
Just to clarify, that's an appeal from a judgment of conviction, correct? The statute, as opposed to any appeal? Or do you have a view on what the statute provides?
The way I read the statute is that we're talking about a direct appeal. So this is after a case is either pled or tried, and then the defendant is subsequently sentenced. And that then goes through the normal appellate process, either to the Court of Appeals or to this court. And while that case is pending, the way I read that case law, or the way I understand it, is that if there's a subsequent change in the law, the defendant will get the benefit of the change in the law during that appeal. To go to this case, the defendant was sentenced in May 2015, and he was sentenced. He did not take a direct appeal. He did not challenge his sentence at that time. Subsequently, he filed a motion to correct an illegal sentence in June 28, 2019. And that challenged his Missouri municipal convictions, which are not at issue today. But the ultimate effect of that was he took an appeal. The state essentially agreed that these should not be counted, and his criminal sentence was reduced. His history going from an A with 3 person felonies to a B with 2 person felonies. Those person felonies were Missouri attempted robbery convictions. Now, while he was being resentenced on that, the defendant challenged those Missouri robbery convictions. And it's an interesting argument. If the court reads this in volume 14 of the record, it seems my reading of it is that the parties agreed that the proper test for the district court to apply was Vandervoort. And to get down to the essential detail of this case, if Vandervoort is applicable, then his convictions are properly classified as person felonies. If Wettrick applies, they should be non-person felonies. I think that's clear to the parties and this court as well. The district court found that Vandervoort did apply and affirmed those convictions as person felonies. The defendant took an appeal to the Court of Appeals, which held that the defendant was entitled to the benefit of Wettrick. The state filed its petition for review in that matter, and we're now here before the court. The state's position is that State v. Clark 2021 case effectively barred the Court of Appeals from doing what it did and giving the defendant the benefit of Wettrick.
The Court of Appeals thought Clark was distinguishable. Would you address why that's presumably wrong from your point of view?
My reading of the Court of Appeals is that Clark was distinguishable because there was no illegal aspect of his sentence. And in this case, the defendant did have an illegal aspect of his sentence, which was the Missouri misdemeanor convictions, which the state ultimately agreed shouldn't be counted against his criminal history. I think this case is distinguishable because the Missouri robberies, attempted robberies, that was not an illegal aspect of his sentence. Those were under the law at the time he was originally sentenced. the closest approximation to Kansas robbery, so it was properly categorized as a person felony. The edge which the defendant is trying to get in this case is that, well, if any aspect of the sentence is illegal, then any other aspect can later be challenged. And that is just that's sort of a roundabout way of getting a motion to correct an illegal sentence in.
It doesn't, don't all proceedings arise from the filing of a motion for a legal sentence? Aren't we just still in that course of procedures that come from that vehicle? And doesn't Clark say that matters that rise from a motion to correct a legal sentence sets those rules? Clark doesn't really make the distinction about whether or not the second sentencing might be legal or illegal, does it?
And that's one of the things to which I think this important for the court to clarify today, just to what extent Wettrich is alive, and it does have effect. The important thing here is that when the defendant was sentenced in 2015, there was no direct appeal taken at that time in his sentence. The Wettrich didn't apply his original sentencing. And then when he filed his motion to correct an illegal sentence, even back in June of 2019, Wettrich had been overruled legislatively, and then subsequent rulings from this court held that it's a change in the law that doesn't apply retroactively. So it wouldn't apply at that stage either. So if it doesn't apply at those two stages, there's no reason why it would apply on appeal. And Clark also.
Can I clarifying question? What was the status of the law when he was resentenced?
The status of the law when he was resentenced in 2022, Clark was the last word which the court had guiding it. And I think that that's significant because the parties were under the impression that Vandervoort was controlling the law.
I'm sorry, just walk me through, when was he resentenced?
I don't have the precise date, but it was in June of 2022. Or I'm sorry, in 2022.
So he files his motion in 2019, but doesn't get resentenced until 2022. Is that right?
That's correct. But that original motion to correct an illegal sentence, that addressed the Missouri municipal convictions. They did not address his Missouri robbery convictions. He subsequently filed two other motions to correct an illegal sentence.
So it worked its way through the appellate process, went back to the district court in 2022. And so he filed the motion to correct that we're currently hearing isn't the 2019 motion.
That's correct.
It's okay. Thank you. That helps me. Sorry.
No, thank you, Justice Stegall. Your Honors, I see that I am out of time for my opening portion, unless there are any questions. Thank you.
May it please the court. I want to address a couple of things. First, the Court of Appeals did find that Clark this case is distinguishable from Clark. I believe that the Court of Appeals is correct in that regard. This is not like Sidney Clark's case. This is not like Charles Moore's case. This is not like a Murdoch case. When Chris was sentenced in 2015, as the parties agree, his sentence was illegal, as pronounced under the law in 2015. Regardless of whether Vandervoort applied, Wettrich applied, his 2015 sentence was illegal.
What made it illegal? Is it the inclusion of the municipal court convictions, or what aspect made it illegal?
Yes, the inclusion of those 7 Missouri municipal violations, which aggregated into 2-person felonies in 2017, should never have been scored.
But what about at the time of his original sentencing? Was it attempted aggravated the robbery convictions? Those were correctly scored, weren't they?
We haven't made any arguments in this briefing about whether or not those were correctly scored under Vandervoort. Because I don't actually think that that's relevant, because Mr. Jacobson's sentence didn't become illegal because of some change in the law, like in Clark and Murdoch and Charles Moore's case. His sentence was illegal when pronounced. So we're not saying that Clark should be overturned or that Clark is wrong. We agree that the legality of a sentence is determined based on the law in effect at the time of sentencing. And based on the law in effect at the time of sentencing, Mr. Jacobson's sentence was illegal. So his sentence was necessarily vacated, and he was necessarily resentenced in 2022. And in 2022, Wettrick ruled the comparability analysis of out-of-state offenses. He had to get a new PSI. They had to recalculate. And in 2022, Wettrick was the law of the land for Mr. Chris Jacobson. It should have applied, and the Court of Appeals correctly held that it did.
Let me ask you a question. So if we drill it down, the issue here is, to me, and you can correct me if I'm wrong, that is this a direct appeal or an appeal from a denial of a motion to correct an illegal sentence? Those are two separate things. And do you get the benefit regardless, right? Okay. So when you look at the statute, the plain language of the statute, 223504, which was amended in 2019, when you look at subsection C2, change in the law means a statutory change by an appellate court, unless the opinion is issued while the sentence is pending an appeal from a judgment of conviction, not an appeal from an illegal sentence, but from a judgment of conviction. How do you respond to that?
Yes, Your Honor. So I think two parts here. So is it a direct appeal, or are we sort of in the same train as this motion to correct an illegal sentence that was filed in 2019? Our position is this is a direct appeal, right? Because when his sentence was pronounced, it was illegal, it was vacated, he had to necessarily be resentenced.
But it's not, would you agree it's not an appeal from a judgment of conviction?
Right, this is now an appeal from a judgment of an illegal sentence.
Right.
Which, I mean, to be fair, Your Honor, if a client is convicted and they get a presumptive sentence, or we think something is illegal in the sentence, we can file appeals that are direct appeals without challenging our client's convictions, but challenging that the sentence is illegal as pronounced. And that would be considered a direct appeal, even though we're not challenging our client's convictions. We are just taking an appeal from the sentence.
Right, but there are time limits for a direct appeal, correct?
That's correct, Your Honor.
Was this filed within the time limit of the?
Well, our position would be that it was a timely direct appeal of the resentencing. It would not be timely.
No, but I'm talking
Yes.
about the motion to correct a legal sentence, which was filed in 2022 on this issue. Was that timely filed within 14 days of judgment?
Our position would be yes, because we think the judgment comes from,
Judgment of conviction.
right. But our position though is that
When was he convicted?
in 2015.
Thank you.
But to your second question, Your Honor, which is, do I think Mr. Jacobson gets the benefit regardless? My position is that he does. Again, his sentence didn't become illegal because of a change in the law. Wettrick didn't come down during the pendency of his appeal. But when he was resentenced in 2022, Wettrick was the law of the land. Vandervoort was no longer the law of comparability. You have to use the comparability analysis or the statute that was in effect at the time of his offense, which says that to score a person felony, the out-of-state conviction needs to be comparable to a Kansas conviction. So that's the statute we're looking at. And the comparability analysis in effect in 2022 is Wettrick. So I think that regardless of how we get there, Mr. Jacobson gets the benefit of Wettrick in 2022.
Isn't the point of Clark, though, to identify a discrete set moment in time in which we'll analyze the legal framework? And as I read Clark, it suggested to me that that discrete point of time is when the original sentence was imposed. So, I mean, I'm not seeing the distinction other than the legality versus illegality of the original sentence, but procedurally, otherwise, it's pretty similar to Clark, it appears to me. And it seemed to me that one of the major takeaways of Clark was to kind of pin that point in time. And as I read it, it seems to me that that's the original point of sentencing, when the original sentence is pronounced, regardless of its legality or illegality. And tell me where we might be wrong, or your view on that.
So our view on it, right, again, we don't disagree that the legality of a sentence is determined based on the law in effect at the time of sentencing. But we think that once the legality is either determined or found illegal, then we are no longer pinned down by that discrete moment in time. We're not here today to talk about whether or not his 2015 sentence was illegal. It was
I'm
illegal.
sorry to interrupt, but it sounds like you're saying the original sentencing date is 2022.
That's correct. Yeah, that's our position, is that the original sentencing date is 2022.
So we could apply Clark and you could still prevail.
Yes, yeah.
From your
yes,
perspective.
Yes, from my perspective, regardless of if you think this is a direct appeal or something else, Mr. Jacobson prevails, because we determined at the discrete moment in time in 2015 when he was sentenced, we determined, the parties all agreed, his sentence was illegal. So he was-
Wasn't that the same argument made in Clark though, however? That they were trying to pin it to the time where the illegal sentence was corrected and resentencing from that, or that's the relief that they requested, as opposed to the original date of the sentence pronouncement.
Right, but in Clark's case, in 2005, when he was sentenced, based on the law in effect in 2005, Mr. Clark received a legal sentence. So he doesn't get any benefits. There's no change in the law that helps him out. In 2015, when Mr. Jacobson was sentenced, it was illegal. That is what distinguishes this case from Clark, from Moore, from Murdoch. When the sentence was pronounced, the original sentence in 2015, it was illegal and all the parties agree.
What's your best case or argument for the proposition that a finding of illegality in part of a sentence renders the entire sentence illegal?
I mean, I guess it would be that the Court of Appeals vacated the entire sentence. I don't know that I have a good case side for that, but
Well,
they
I
didn't
think
say
the-
we're gonna vacate part of the sentence and
I-
just remand for a little bit. We're vacating the whole thing. You have to start over.
Don't we have case law that suggests when part of a sentence has been found to be illegal, the lower court does not have discretion to alter the portions of the sentence that were not found to be illegal?
Candidly, Your Honor, I'm not sure. I could.
If
I
that
could
was the
brief
case,
that.
would it cut against your argument?
I guess it might cut against my argument here, but again, the parties all agreed that this sentence was illegal in 2015. It
Well, they
all
agreed
needs to
that
be
part, they
vacated.
agreed, to be accurate, they agreed that part of the sentence was illegal, right?
Right, right. But then agreed that any other criminal history challenges could be raised in front of the district court. So in 2022, when he's resentenced and we re-raise these issues, wet trick is the law of the land.
And it does go to criminal history, which taints the entire sentence.
That's correct, Your Honor. There are no other questions. I will waive the rest of my time. Thank you.
Thank you. Mr. Obermeyer, you reserve 5 minutes.
Justice Standridge, I believe your question about whether or not this is pending a direct appeal, I think that that's probably the easiest way for this court to address this case. It's the state's position that this is not a direct appeal. Therefore, there is no change in the law which occurred.
Why does that matter? I mean, as I understand defendant's argument, their defendant's saying, look, he was sentenced in 2022, just apply 2022 law.
Well, because 2022 law is the court has to apply the law in effect at the time the defendant was originally
Well,
sentenced.
no, but that's exactly the point that I think the defendant is arguing, is that all went away. There is no quote unquote original sentencing date. He's only been sentenced one time, and that happened in 2022.
Well, the sentence that was pronounced in 2015 might have been illegal, but it nevertheless does function as a sentence for which he could have taken a direct appeal, but which he did not. And he might have received the benefit of wet trick had an appeal been taken there and it ultimately been decided at the same time. So I think that's the distinguishing factor. Procedurally,
That's fair.
well,
I mean, really, if you're talking about the sentence being illegal at the time that it was first pronounced, okay. And nobody challenges it at the time. Then you come in with a motion for illegal sentence, and I get Clark, I mean, but once it's illegal, why can't the defendant get the benefit of the change in the law, basically, that occurs where, I mean, in other words, had he appealed, done a direct appeal and gone up, he's gonna get the benefit here. But because they didn't, and they waited for the motion to correct an illegal sentence, now that benefit has gone away. Just seems like we ought to figure out this, I mean, sentencing stuff makes my head explode anyway. But it just seems like we ought to be applying the same rules for everybody all the time. So again, how is it fair to look at the law the way you just tried to argue it?
Well, Justice Biles, that is the process which it goes to. He received all procedural fairness. Even if he chose not to appeal, and that other defendants have received different results from their criminal sentences. That's just the unfortunate result, that some will receive a benefit and some won't. But it's fair.
Counsel, wouldn't it be true that if he did a direct appeal in 2015, that Vandervoort would be, Vandervoort was the law of the land until 2019. So if it would have happened in a direct appeal, then it would have been exactly the 2015, right?
Agreed.
So he wouldn't have gotten the benefit, correct?
I agree, Justice Standridge. And just to clarify, I was working under the presupposition that his appeal would somehow last until Wettrick applied, but I agree.
4 years?
I
We're slow, not that slow.
did not mean to impugn this court, Your Honor. I apologize.
I would just come back to this whole, did he appeal, didn't he appeal? It seems to me be missing, I guess, the point. I don't see why the question of the appeal is even relevant, because the fundamental question is, when was he sentenced? And I still haven't heard, like, what's your best argument to rebut the defendant's claim that he was sentenced in 2022? Based on the quirk of this case is that there was a finding of illegality that has nothing to do with the issues before the court, right? That finding of illegality is not contested.
Yes, that's correct, Justice Stiegel. I think that the best argument I have on that is that the Missouri convictions, those were legal when the sentence, as from the state's point of view, was pronounced, albeit illegal.
That criminal history was correct.
That criminal history was correct. So, and those convictions supporting that part of his sentence were and remain.
Wouldn't the sentence itself have been illegal, however, because it placed the defendant in the incorrect grid box?
Yes, it would have. It would have been in 2015 illegal, but not all the classifications. So that's the distinction.
But the entire sentence was illegal.
In terms of the sentence, yes, itself.
And that's the distinction from Clark, because in Clark, we said, wait a second, that original sentence in 2005, although in its winding way to us was at one point held to be illegal, we ultimately concluded that in 2005, it wasn't illegal. And that's the critical distinction between this case and Clark, right?
That is, but I think that Clark also, procedurally, he was in a stronger position to assert he was entitled to the benefit of the law, a change in the law brought by Wettrick, because as I read his case, he was sentenced in 2005. He filed a motion to correct an illegal sentence in 2017. The Court of Appeals reversed based on Wettrick. He was resentenced in 2019, and then this court held clearly from that Wettrick did not apply. So procedurally, I'm not sure.
Well, that's because the resentencing in 2019 was wrong.
And the state's position would be that the resentencing or the reclassifications would be wrong as well, which is that goes to the resentencing.
When is the resentencing date that is advocated by the defendant here as the pinpoint for the actual date of sentencing?
In 2022, when he received.
So then the municipal convictions are back in play? Is that how that would play out? Because that law has changed, right?
That was not briefed by the party.
I understand, but let's just say hypothetically, if a defendant in that position, then if you're going to, take that view, then you're going to have to take the good with the bad, theoretically.
That certainly is a potential consequence, yes.
And so then, just jumping off where Justice Wall says, then if another motion to correct the legal sentence is filed, in this case hypothetically, then it would be even more different. I mean, if there's a change in the law, I mean, this could go on forever, right? Because every time there's a new sentencing date, it's all going to depend on what the new law is, and it just ad infinitum.
And that's what I think the court was trying to do with Clark, is to put a definite date where Wettrick is effective from the date it's decided until the date it's legislatively overruled or subsequent court rulings state that. Unless there are any further questions. Madam Chief Justice, may I briefly close?
Yes, you may.
It would ask that the court affirm the decision of the district court denying the defendant's motion to classify his Missouri attempted robbery convictions as non-person felonies. The proper standard in this case is the standard of Vandervoort, which was the controlling law when the sentence was originally pronounced in 2015. We ask the court reverse the Court of Appeals and affirm the district court. Thank you.
Thank you. Thank you to both counsel for your arguments in this matter. The court will take this matter under advisement.